Hello, good afternoon, and welcome to The Law. This is your Legal Light, and this is your Health Law. Now, this afternoon, we are going to endeavor to give you thorough education on what these about the laws that criminalize the spread of false information with intent to cause fear and panic, or fear and alarm, and the display of guns. Is it becoming a subculture? What exactly is the law on these issues? I'm Samson Ladi Anyanini. We'll be right back. Welcome back. This is The Law. It's your Legal Light, and it's your Health Law. We're dealing with fear, panic, or fear and alarm, and gun brandishing culture. What does the law say about all of these? You would realize that the police have begun cracking the whip, particularly regarding these matters. I have guests who will assist us to understand these laws in a way that helps us to avoid getting on the wrong side of the law. Thank me after the show. My guests are Bernard Agote. He is lawyer, Gomda and Associates. Joining us also via Zoom is Ebenezer J. Bediako. He's lawyer, J. Bediako at law. Gentlemen, thank you so very much for making the time to be on the show.
You're welcome, and thank you very much.
Great, great. So let's begin with you. What is it that people ought to know? And of course, we are going to also treat the question about whether bail is automatic, because there's a lot of a hue and cry about why certain persons are denied bail by the court at certain times. So what exactly does the law say about the crime of spreading or publishing false information, for which we get into trouble, and how do we avoid it?
Thank you, and thank you to your cherished viewers. You know, the law, especially the criminal law, is much interested in prohibiting acts that sin against the public morality, decency, and to protect people from injury, from some threats. And so the offense, as it's provided for under 208, falls under a part of the law which is generally headed offenses against the peace.
Okay.
So you realize that under Chapter 3 of Act 29,
which is a Criminal Offences Act.
Criminal Offences Act, most of the offenses mentioned here are those that sin against the peace of society. And so punishment is provided for for acts which tend to breach the peace of society, or put society in the pandemonium, more or less, so that people can go about their businesses. There will be, society would things will move on smoothly,
right,
without any fear of harm, or without any panic in the system.
Okay.
Now, if we look at 208, 208 says that a person commits a crime when he or she publishes or produces a statement, rumor, or report which is likely to cause fear and alarm to the public or to disturb the public peace, knowing or having reason to believe that the statement, rumor, or report is false. So that is the definition of the offense of...
You speak about statement,
yes,
rumor, or report. And you're saying that the ingredients of this offense is what?
So the ingredients is a publication of a statement, or a report, or a rumor. Now, the question is, what would constitute publication? I'm sure we'll get there as we proceed. Then also, the information or the rumor or the report or the statement which is published must be false.
So that's overriding?
Yes, it must be. It says a rumor which is likely to cause fear and alarm to the public or disturb the public peace, knowing or having reason to believe that a statement, rumor, or report is false.
It's false.
So that rumor or statement or report must be false. And it must be capable of causing fear and alarm to the public.
It says to the public to disturb, it says something.
To cause fear and alarm to the public or to disturb the public peace. So it is not only just causing fear and panic, or the likelihood of it causing public, disturbing the public peace. So that if you can I give an example? You go to you are a hunter, you go to the bush and you say, I saw lions coming towards the community.
Okay.
That basically would put the community into some pandemonium. And so if it happens to be false, you can imagine the havoc it would have caused society.
So the overriding consideration is that it's false.
It must be false.
Okay.
It must be false. So that's one of the key ingredients of the offense. It must be false, and you must, you see, something, if you look at it very carefully, you would realize that they don't only talk about fear. It also says an alarm. Fear and alarm to the public, or to disturb the public peace. And so even if you're in the bus and you don't see a snake, and you say you found a snake, and then there's stampede, we could probably bring you under this provision.
Okay.
So it is a provision that prohibits persons from just making statements.
Unnecessarily causing commotion in town.
Exactly. And you can imagine how people will react to some of these statements. So that is why the law specifically makes provision.
But is it not too much when the law says the false statement, rumor or report should be first it should be false and should be likely to cause, meaning that it is possible that it may not have caused, but once it has the likelihood, potential to cause fear and alarm, or it has the potential to disturb the peace, then you are caught. Is that my understanding?
Yes, you are not far from. You are not far from. You see, the point is, if what you are saying is false, and you have not taken steps to verify whether what you are saying has any truth in it whatsoever, then it will. You see, we are trying to punish a guilty mind, and also an act. And so, what was your state of mind at the time of making that statement?
All right.
Was there any belief on your any basis for you to believe that this is true? A reasonable mind would believe that this statement you are making is true, and so you are making it. Did you verify? Did you cross-check this fact?
Right.
Before throwing it out to the public, such that when the public receives it, then it creates problems for society.
So the law expects that you will do a certain verification, you will check, you will double check, cross check, to be sure that the information you are dealing with, the statement you are dealing with, the rumor or the report is not false. So something, if you read, is it just that you check to be sure it's not false, or that it doesn't have the likelihood of causing fear and alarm and disturbing the peace?
Now, something, if you read subsection 2, this is what it says.
Okay.
It is not a defense to a charge under subsection 1 that the person charged did not know or did not have reason to believe that the statement, rumor, or report was false, unless it is proved that prior to publication, that person took reasonable measures to verify the accuracy of the statement, rumor, or report. So the subsection 2 explains what you are asking, that is it just the statement being false, or now my interpretation of this is that if you want to put up the defense to the offense and say that, well, I made it believing it to be true, then the question then is, what steps did you take to verify whether this statement you are making is true or not?
So when you are caught under the law and you want to say, I didn't do what you're saying I have done because I believed it was true, or I believe it was not false, then what you're saying from the reading of the law is that the law enforcement agencies or the court will check whether you are taking reasonable steps to verify the accuracy of the statement. Then if they confirm that, then you could be set free.
So if you look at it again, it says it is not a defense to a charge under this section that the person charged did not know or did not have reason to believe that statement, rumor, or unless it is proved that prior to publication that person took reasonable steps to verify. So if you can show that you took reasonable steps to verify, of course you can verify and probably get it wrong. So if you get it wrong, you can be pardoned for that.
Right, because you took steps.
Exactly.
Okay.
Once you took steps to be sure that what you are saying is most probably going to be true.
All right.
It could be exonerated, it could be exculpated by...
Interesting. And you said we'll come to the portion of what constitutes publication.
Yes.
I'm sure we'll come to that very soon. Ebenezer Ejebidiako, thank you very much for making the time to join us.
Good afternoon to everyone.
Great. And Ebenezer is joining us via Zoom. Hoping to see your face. He's joining us all the way from the Ashanti region, Kumasi. Ebenezer is also a law lecturer. Now, what would you say about this particular law and what it is intended to do for society, and what we should all do to avoid being caught by this law?
I believe this requires that we do not conduct ourselves or undertake any action that to some extent would breach the peace or disturb the public interest or will cause alarm or, as we said, fear and panic. The reason being that people have their rights and their powers as well. And they have rights.
No, I think the Zoom is failing us. Maybe we should get Ebenezer via phone. Perhaps that would be useful. The Zoom is failing us on this part. So we'll try and raise him back and get a law teacher's perspective of what is going on. Yes, so as you read, until there is publication, until the thing has been put out there, there is no offense.
Exactly.
So what is publication?
Okay, so I explained it very simply to mean that making it known to at least one person, that could constitute publication. But to say that this person published it and so he's being brought under this, under section 208, I don't think publication to one person, as in the case of defamation, when you publish to one person, then you have defamed the person, would suffice under this. Because over here we are looking at the effect it will have on society.
Right.
So if I come and tell you and whisper to you that I saw a lion at the reception. I've said it to you only. You can be in fear. But as to whether I have published it to cause, because the consequences is public peace, cause fear and alarm to the public or to disturb public peace. So I understand this to mean that the publication must be widespread.
Okay.
Now, what is widespread publication? In today's world, we could talk about social media.
Right.
We could talk about even traditional media, television, newspaper publication, or if you take a gong and beat in my hometown, it would constitute publication.
Right.
Publication could also mean probably shouting it out, maybe in the lorry park, or at the market, or in front of the chief's palace. Those should constitute publication under this law.
Right.
And I initially mentioned that mentioning it to one person in the ear could not suffice. Maybe would not suffice, because I need to explain that if you say it to one person, you cannot be said to be saying it to
the public.
To the public,
okay.
In the sense of this provision, because the provision seeks to punish for the effect it will have on society as a whole,
all right,
not one person.
All right.
So that if, unlike defamation, where when I say it to one person, then I have brought the reputation of that person into disrepute, even before one person.
All right.
Then one person should suffice. But if we're in a classroom, or we are at a pub, or we are at the office, and I scream a false statement, or I go on the internet and type.
You know, some time ago there was this information that suggested that there was going to be something people needed to get out of their rooms, and some people actually got out and went to look for, parks, playgrounds to stand on.
Yes.
It turns out it is false. If you can trace to who did the circulation, then this law will catch the person.
Exactly. I think, was it the same situation when people were told to leave their rooms and probably be in the compound or something?
Exactly.
For example, if somebody has no reason to say that there will be an earthquake, and you publish that there's going to be an earthquake, we all know how we receive such news.
Right.
And the effect it will have on our everyday life.
So such news should come from an official source, maybe the Ghana Meteorological Agency,
exactly,
or something like that. Then once they pass it on, we can also pass it on.
Exactly.
Right.
So that is why the law says that you must have a reason to believe it to be true, and that reason should be verifiable.
Right. That you took reasonable steps.
Exactly.
Okay. Reasonable measures to ensure that to verify the accuracy
of this.
Right. So in this time when things are being shared on social media, WhatsApp, everything, I just get the thing and I pass it on. Am I at fault?
Yes, you'll be at fault.
Okay, hold on. Yes. Let's hope that we have a better connection to you now. You began your explanation as to what this law is intended to do for society, and also to proceed to tell us what we should do to avoid being caught by the law.
Thank you once again. I believe it's
Yes, it is.
Okay, thank you. The essence of the law, per the wording, is this, that no one should publish, reproduce any statement, rumors, whatever it is, that has the possibility of causing fear or an alarm, and that may possibly disturb the public peace. The essence is this: everyone in this country has the right to have this or her peace of mind. Every person has the right to live peacefully. No one has the right to put any fear in me. No one has any right to cause me to be alarmed. So the law says, you do not have any right to do any of all the things prescribed in the law. If you intend to do that, then you must prove or take steps or prove to the court that you took steps to verify the veracity of the content you published. And I believe that alone in itself may not necessarily be a defense. Because if you took steps to verify and you got to know or ought to have known that the information you are publishing or reproducing may cause fear, alarm, or potentially...
And it is false. Hello, have we lost the JBD again?
Hello, I can hear you.
Yes. So you were making a statement and I said, and it will cause fear, then what happens?
Then, as the law says, you commit an offense, which is a misdemeanor.
All right.
If you verify and you get to know that that information is false, then you don't have to publish or reproduce.
Right.
So the moment you publish any information or rumor and it's found out to be untrue, if it is false and doesn't cause any of those elements, that may not necessarily be an offense. But if you publish falsehood and it leads to fear, alarm, or possibly disturbing the public peace, and you knew or ought to know, had reasonable reason to believe that that information is false, it's not true, then you are causing or committing a particular offense. And so the catchword comes that if you check the accuracy, the truthfulness, and that information is not true, or it is not correct or right, then you don't publish it.
But what does the law mean by saying that if you took reasonable measures or steps to check the accuracy, you could be exonerated? That means it would have been published anyway.
Good. So you look at the law in two steps. The first one is taking reasonable measures to verify. My argument is, if you indeed took those reasonable steps, you ought to have known that information is false.
But if you took those steps, you could still come to the position that it is reasonably believable, and for that reason you publish it.
Perfect. Then you would have, as it were, met the requirements of the law. But you and I would agree that in most instances, before a person will be charged with this offense, most people would not have done what the law requires them to, i.e., taking those reasonable steps. And you are a lawyer and also a media person. Hardly would you come out with news for any particular item without verifying the content.
Right.
So that duty on you is reasonably applicable to anyone in the country. Do not just go out there publishing information that you know or ought to know is not true.
Right.
Particularly so, when looking at the content, it may cause fear, panic, or alarm.
Right.
Let me add a bit on the publication.
Yes, I would like you, if you can hear this broadcast directly, let's use your phone and turn the system by you off, because we have a bit of feedback. Thank you. You can proceed now.
Good. So publication. Okay. When a person sends information or makes a communication to any person other than the person making that statement or sending out that particular communication. So, for instance, I am here in my office. In law, I cannot publish any statement or make any like a communication to myself. If I communicate to another person, whether by a phone or any medium, it doesn't matter.
Okay, we have to pause with Ebenezer because his line is still not the best. The feedback we're getting is not the best for now. So we will try and rectify the line with Ebenezer so that we can have a clearer, position, as it were, with him. Now, I had asked you that question about, I'm sitting here, somebody sent me, and we see this thing happen a lot of the times. Somebody sends me a message, I just pass it on. Perhaps sometimes you don't even read to be sure you know the content. You just pass it on. Why will I be guilty of this offense when I do this?
Yes, so probably this should be a wake-up call to all of us. That the moment a statement or a rumor or a piece of information leaves our phone to another platform, which could end up in another person's inbox or another person's domain, that could constitute publication. Now, we need to cross-check these things because you will be held liable if it so turns out that what you are sending out is false. And like you said, we receive and just share. We receive and share without any attempt to verify, to be sure that what we are sending across is indeed true or not. I don't think
if I'm arrested, I will say it is Bernard who sent it to me and I forwarded. I didn't read.
Well, then there you go. You did not even read to be sure that what you. So you should read and verify. Read and verify. I mean, it shouldn't. Some people are just fond of sharing. Sometimes they will even share that if you dial a certain number, your phone will explode. I don't know. Or yes, those things keep coming up.
Yeah.
And if you even look at some offenses relating to child pornography and how the publication is interpreted under those laws, we should be very careful when we are sharing certain things.
People receive these graphic stuff and they just send it.
Just push them. You see a child being molested, and then you only feel like sharing it. I mean, that child has some right of privacy. Or sometimes I even take exceptions to when some teachers record their pupils who probably get answers wrong and publish them. Those are, I mean, we are not digressing, but just so we all know what publication means in this context. We publish these things to see them. The whole world will react to it. The person or subject matter of the things we share don't remain with us. People form opinions about it. It affects people's daily lives. It has potential of even affecting many more people than we think of.
Right. And in that respect, though, you may not be sharing false information because it may be true that you have received a video of a child being molested and you are sharing.
Yes.
It may be true, but in fact, in law, you are not supposed to do that. The child is supposed to come under protection. They are not supposed, and all of that. But under the Electronic Communications Act, will that be something like that? Will that be an offense where it says that a person who by means of electronic communication service knowingly sends a communication which is false or misleading and likely to prejudice the efficiency of life-saving service or to endanger the safety of any person, ship, aircraft, vessel, or vehicle commits an offense and is liable on summary conviction, yeah. How is that also, does this also come in on this area of law?
Okay, so looking at the Electronic Communications Act, so that if you look at the application of the law per se, it seems to be for those that are regulated under that act. So basically radio stations, persons who come directly under the NCA and all. But if you look at the offense created, it gives it a more general application than the act, the application of the act itself. Yes. So if you ask me, I think the provision in Section 208 is more specific to the general populace,
right,
than the provisions under the Electronic Communications Act.
All right.
But the ingredients basically are the same.
All right.
If you use a means, which other means, and in this case, they are being specific, electronic communication services. If you use those means to publish things which would end up having the same effect as we have under Section 208, you'll be committing an offense.
But there's a slight difference too there, because it asks misleading. So there's a difference between something being false and it being misleading.
Well, there will be a very little line then, if there is any difference.
All right.
Because if it is in 208, we are not saying that whatever you say must be true. We are saying that before you share it, just be sure that
it is not false.
It is not false. Whereas under the Electronic Communications Act, the provision says information which
is false or misleading.
False or misleading. So when we say you are misleading me or you are misleading somebody, it could have a bigger meaning than just it being false.
Right. Right.
You know.
Okay. So
now, something. If you look at the case of Edusei versus the Republic, it's a 1975 case.
Okay.
Now, this is somebody who wrote to Asantehene.
Okay.
To say that some people were plotting to overthrow the government. And the police investigated the matter. And it found out that there was no basis whatsoever for that publication. The person was convicted under 208.
But you were saying, if I communicate to one person, that is not sufficient because the law says to the public. So if the person wrote to the Asantehene, that's not publication.
You see, when I said coming to whisper into your ear,
right,
as against shouting it out in a bus,
right,
I was just trying to create the distinction that, look, if somebody comes to whisper something into your ears, it could probably cause you fear. But to distinguish between cracking jokes and saying things that can lead to chaos in society.
And in that manner too, doesn't affect the public.
It doesn't affect the public. It doesn't affect. But this is you writing to the Asantehene, who is more like an institution, saying that these persons have taken steps to overthrow the government. If we find out that you have no basis whatsoever for saying this, you should not be let go.
Okay. All right, hold on. Now, let's see if Ebenezer's line is better. Hello, Ebenezer. Great. It sounds a lot better now.
Thank you.
Right. So you got to a point where you were making the example of you sitting in your office. You cannot make a publication to yourself. If you can proceed from there.
Good. So a publication would mainly relate to communicating with some other person other than yourself.
Okay.
So as I said, if I'm in my office and I speak myself, that would not amount to publication in the eyes of the law.
All right.
However, if I tell any other person any particular information or statement which would contradict the content of the law we are talking about, then that would amount to a publication. If I also receive a message and I pass it on, that would amount to reproduction. So if I publish, it emanates from me. If I reproduce, it means I get it, and as you said, you forward. So before you forward, verify, check, be careful.
Yes.
Because what you are forwarding may lead you.
But wouldn't you agree with Bernard when he says, in the eyes of Section 208, which is false report, statement, or rumor likely to cause fear and alarm and disturb the public peace, it is the publication must be to the public and not to one individual, as in defamation situations is the case?
It's perfectly true. It is the public.
All right.
So we were trying to define publication.
That's right.
If you situate it with the context of the law, then the law has the public in mind.
Right.
Not individual. That's also people, but it's the public.
Right. Okay. So we let's bring in the other aspects, the brandishing gun culture thing. What's the offense in that? I have a gun, and I want people to see that I have a gun, or somebody is doing me something wrong, and I want to let them know that if they dare, I'm going to kill the hell out of them. And I'm showing the gun in the public. What have I done wrong? I haven't used it. I haven't used the gun. I haven't, pulled the trigger. What's wrong with that?
Okay, let's start from this. Do you or does anyone have an inherent right to own or display guns in public? That's the first question I want us to answer. No one has the inherent right. That right to own or even possess a gun is given by law, a statute.
Okay.
So, if you look at the Section 1 of NRC 9, a person who owns, possesses, or controls arms or ammunition shall forthwith apply to register them at the nearest police station.
Okay.
So that means that you can own, possess, or you control arms only when they have been duly registered. So that means you don't have an automatic right to own them.
Right.
So you now have them. And the assumption is that you have done what the law requires you to do. Done, i.e., the registration. Now, the law says, if you have that right to own it, we do not want a situation whereby anyone can just get up at any point in time and start displaying those arms or ammunition. So, if you would want to do that, you must get a prior written consent of the IGP before you can do those kinds of things. So then, if for whatever reason you believe someone, the person you want the person to know that you also have ammunition, you have arms, you can protect yourself, then you come and show it in the public. That particular act has been made an offense. So the second says that the person shall not, except in accordance with the terms of the permit granted under this act, or with the prior written consent of the IGP, publicly display any arm or ammunition, or discharge a firearm, or any other weapon in a public place. So then, if you do not have a permit, or the permit does not allow you to display your arm publicly, or you don't have the prior written consent of the IGP, you cannot do that.
Okay.
If you do that, then...
Yeah, now hold on for me. Now, Bernard, I don't understand this.
Okay.
You have given me the permit to hold a gun. And in that same law, it says I am not permitted to display the gun or discharge it in the public. What is the purpose of the gun that you have given me permission to keep?
Samson, I don't think that's what Section is it Section 8?
Section 7 there.
Section 7 of the Act says, it says that no person shall accept in accordance with the terms of a permit granted under this decree or with the written consent of the Inspector General of Police publicly display any arms or ammunition, including explosives, or discharge any firearm or other weapon in any public place. So, we are not saying when you have a gun which is licensed, you cannot display it. You can, well, let me put it this way. We are not saying that if you have a registered gun, you cannot discharge it. You can discharge it and use it in accordance with the permit that has been given you.
Okay.
You have a permit, but the permit will have its limits. It will have a time frame. The permit could say that you cannot use it in this particular area. You can't take it here, you can't take it there, so you cannot do that. Now, the word brandishing, you said brandishing culture. So having it and brandishing it.
Right.
Now, if you read the Possession Act, the law on possession generally. Now, when you are caught with the prohibited, let's say, gun, the onus is on you to come and show that you have permit to use it the way you are using it, or to hold it the way you are holding it. So, for example, I always say that, look, if you are into entertainment and you are going to act a movie and you need a gun for that purpose, you just go to the IGP and say, I mean, this is the business I'm into. This is what I'm going to do. So I need a permit for this purpose. So when it is given you, we know that this is the reason why we are giving you that. So you can probably do show, quote and unquote, that you are showing
realize
off
that law also clearly says arts like firing of musketry.
Yes.
Where there are festivals and other things. So in such places, when they are going to display it and, you know, discharge, they can't do it without permission of the IGP.
Exactly. And you see, I don't know why we are now getting here in terms of public discourse on this matter. Because almost every year we hear of people dying during festivals and funerals of stray bullets coming from chiefs and people following chiefs, who, I mean, holding guns and firing them, all in the name of culture. We should have probably had this discussion long ago, because it is killing people. And here the law is express that whether it is for ceremonial purposes or for movie purposes or for production purposes, you need a license to hold it. You know, there is a lot of sense in this law, because a gun today can be a weapon for a movie, but in the next, even during that movie, it can be the subject matter of a crime.
Okay.
So there is the need for the person carrying it to have the required license to use it for the purpose for which he or she is carrying it.
Now let me ask Ebenezer this, and then we'll open the lines to have our audiences join us as we take the other aspect of the bail, which has also become an issue. If someone is caught in this offense that you have, you know, fully laid out to us, for just displaying my gun in the public, I haven't used it to kill anybody or, as it were, harm anybody, why should I be subject to punishment of up to about 12,000 cedis, or up to 5 years, or in certain situations 3 years? Why? Is that not too much? What offense is that? I haven't killed anybody. I haven't harmed anybody.
Law is created for a purpose. There is always a mischief the law would be created or enacted to protect. If you look elsewhere, out of this country, there are major issues when it comes to guns.
That's right.
Even ownership of guns is an issue. Display the discharge. So in our system, you can own a gun. However, get the required permit and use it in accordance with the permit or the written approval by the IGP. If you do not do that, or if you don't go by the terms of the law, that is a crime. And because that crime has been created by a statute with the ingredients and the punishment defined, once you breach it, the law must take its course. 2, if we leave things open and unguarded, what will happen is that now everyone will think that, quote unquote, I'm a big man. I can just own a gun. Then I can just display it. And as my friend said in the studio, if you own a gun, even legally in accordance with the law, the display of it can lead to a crime, either manslaughter or murder, as the case may be. And as you said, we've had a whole lot of festivals. People will fire the musketries and guns and all that. And I think some few months back, a similar incident occurred in Accra. And although the person might have had, I'm saying my boss, I'm not so sure, if he had the permit and then he shot and there was a misfiring or a stray bullet, he was arrested and was charged. So we do not want to create instances or a situation whereby there will be so much insecurity. So the law says, if you want to do all these things, which the law may allow you to, however, you ought to comply with the strict requirements of the law.
All right.
Such that we do not open the floodgates. And also to help the security agencies better enforce the laws of Ghana and protect all of us.
All right. We are opening the phone lines now as we try to talk briefly about why there is hue and cry about not granting bail to people who have been found who have been charged with some of these offenses. But Bernard, now the Electronic Communications Act that we refer to, Section 76, where it talks about if you are circulating false or misleading information, which is likely to cause some problem, then you could face up to 36,000 Ghana cedis or 5 years in jail or both. Then when we come to the fear and alarm one, which also says likely to cause fear and alarm and disturb the public peace, you could go to jail for 3 years. Just the likelihood, not the actual. Is it not too much?
You see, the likelihood is what is being punished, because we don't know how people will react to it. You remember I gave you the example of a farmer, a hunter coming from the bush to say, I saw lions
coming to town.
coming into town. And you can imagine what will happen.
Yeah.
Now, it is the likelihood. What will happen? How would people take this news? If you are in the bus and you say, I've seen a snake in the bus, moving bus, what would be people's reaction, or how would people take this statement? That can lead to people's death.
So should I ask rather that if it actually occurs and we see the effects, and the effect is grave, then you could get the maximum, but if it doesn't happen, then you may get a lesser punishment?
No, you see, when it comes to punishment, my understanding is that there's a lot of discretion to the judge.
Okay.
So when that, I mean, looking at the circumstances of it, because if nobody gets injured, I mean, when the sentencing guidelines, you know, when there's an injury or there's room for reparation and all that, then probably
they could even caution you to and bond you to be of good behavior.
And all that. But if it leads to pandemonium, you know, and people, you see, the law maybe also wants to guard against the situation where people don't just say anything. When you are saying something, there is reason for it. And so people will hear news and would take it for what it is.
That's right.
You understand? So there's a little belief in information that comes around.
Let's quickly add the issue about the bail thing. We have heard, and Ebenezer Bediako, you will also give us your view, Bediako, you also give your view briefly on this. Now, we have heard people are complaining, and they say why. We heard recently that Martin Kpebu went to do some case, and that case says everything is bailable, every offense is bailable. How come some people are still going to court and they are being denied bail? People don't understand it. Can you explain?
Okay, so bail means a very simple thing, that this man has been brought to court on a charge. Now, the trial is not going to take place within a day. It will probably take from weeks, it could take months, it could take years. But this man is presumed innocent. So between now and when he actually goes through full trial, what happens to him? Should he be kept by the court, or he can be released to go home, continue his business, and as and when the court needs him, he will come? And so the main consideration is, will this man or will this accused person be present to face his accusers? That is the main consideration. Now, the issue about Martin Kpebu basically settles one issue, that can the legislature say that when it comes to these offenses, the judge's hands are tied up, and so cannot grant bail? Remember that bail is discretionary. It is the judge who determines.
And the law said if you are accused of murder, treason, hijacking, piracy, defilement, rape, those things, narcotics, you could not be granted bail. Now, because of that case, it says all offenses are amenable to bail.
Yes, amenable.
Yes.
Very good. So it doesn't say that you will get bail. It is just giving the judge a free hand to look at the circumstances of the case, to say that looking at the circumstances of this case, I don't think it is just to keep this man in custody pending his trial. That is the only consideration. Now, if you look at section 96(2), in fact, section 96(3) and 4. This is what it says: the amount and conditions of bail shall be fixed with due regard to the circumstances of the case and shall not be excessive or harsh. So, with due regard to the circumstances of the case. So, it is the circumstances of the case that determines whether this offense or this accused person should be granted bail. There are times when we are in court, there are 3 accused persons. Only 1 person is admitted to bail, or 2 persons are admitted to bail. It doesn't mean that once the offense is bailable, you will get bail. The judge will look at, there are certain things that we state. What is the evidence against you?
Yes,
that has been
but you said the main thing is to check whether I will be available to stand trial.
Yes.
Now, if you check, I have a home, I will not run away from anywhere, and so on and so forth. Why would you want to still keep me? Yes, Bediako.
Well, the court may still want to keep you, having regard to the circumstances of each case, as my friend in the video said. If the court is of the belief, because if you look what this case has come found in Article 14, 14.4, but the court, the Constitution makes a very important statement, if I may go in. The court, it says that the person may be believed either unconditionally or upon reasonable conditions, including in particular. Hello?
Yes.
Good. Including in particular. Including means that it is expansive. including conditions reasonably necessary to ensure that he appears at a later date for trial or for the proceedings, etc.
Yeah, so grant me bail and give me conditions that make sure that I will not run away. Why?
But the court is not obliged to just look at the fact that you will pay a loan. That primary consideration is inclusive of other things. For instance, there's been instances where, depending on the particular charge and the ingredients and the evidence before the court at the time, the court may be of the belief that it is better to keep the person or the accused in police custody to protect the accused person himself or himself.
All right.
It's a very good reason why the court would deny bail.
Okay.
And then in the Martin Table case, the court was emphatic that the power to grant bail is merely discretionary. And the court must look at all the surrounding circumstances of a particular case. So it is not automatic.
Okay.
You have automatic right to bail constitutionally, but you don't have automatic right to be granted bail. So you have the automatic right to apply for bail, but not automatic right to be granted bail. There are two different things altogether.
All right. So having looked at,
people say that. Come again.
Yes. Having looked.
Say that.
Yes.
Everyone has a right to bail, and every offense, as you say.
Yeah. In 30.
An automatic right.
You're right. In 30 seconds, what will be your advice to the public once again on the laws that we have looked at, causing fear and alarm to disturb the public peace by the publication of false statements, rumor, report, and also you displaying gun in the public? Yes, in some 20 seconds.
First is this. There are laws in the country. The laws are meant for our good. Before you take particular action, think of the consequences legally and the consequences on the public as a whole. Otherwise, if the law catches you, you won't do it.
Thank you very much. In 5 seconds, could you say something?
Yes. So basically, when especially on things we share through our phones and our emails and the various social media handles we operate, we need to be very, very, very cautious the things we share with the public.
Thank you very much. Bernard Agote and Ebenezer Ejay Bediako. Bernard is lawyer with Gomda and Associates, and Ejay Bediako is with Ejay Bediako at Law. This has been The Law. It is your health law, and it also is your legal light. I'm Samson Ladi Anyanini. Thank you two gentlemen so very much, and thank you all for watching. We'll come your way next week with another edition of the show.